Please confirm. Yes. All right. Thank you. All right. Sure. So now let's continue. So this is the last part of acceptance. Okay. We will discuss the time and mode of acceptance. This should be very simple. Okay. So in bilateral contracts, acceptance must be very timely, right? So, and the general rule is that acceptance in bilateral contract is timely if it is made before the offer is terminated, right? So let's look at the time and the mode how to send your acceptance. Okay, so the first one is the mailbox rule. Okay, mailbox rule. So acceptance takes effect at the time the offeree sends or delivers the communication via the mode expressly or impliedly authorized by the offerer. Okay. So, and this is called the mailbox rule. Under this rule, it means what? Under this rule, the authorized mode of communication, if the authorized mode of communication is the mail, then the acceptance becomes valid when it is actually dispatched. Okay, it means that it plays under the control of the postal service, not when it is received by the offerer. However, if the offer stipulates that when acceptance will be effective, then the offer will not be effective until the time specified, right? So generally, if it is not agreed otherwise, or it is not stipulated otherwise, then the acceptance becomes valid when it is dispatched. Okay, so if the offeree first dispatch a rejection and then sends the acceptance, so the mailbox rule does not apply. So it means that your acceptance is not effective. Okay. If you read the textbook, you're going to see all this in there. I just mentioned it again. So proper dispatch rule, right? The time and then how you're going to send it, right? The means of communicating acceptance can be expressly authorized by the offerer or implied authorized by the facts and the circumstances of the situations. Right? For example, we're going to say the restatement second of contract section 30 say that by any medium reasonable in the circumstances, unless the offer specifies the means of acceptance. So when an offerer specifies how acceptance should be made, for example, like by DHL, by overnight delivery, by whatever way it is, right? By Grab, right? So express authorization is set to exist. Therefore, the contract is not formed unless the offeree uses that specified mode of acceptance. Moreover, both offerer and offeree are bound in the contract the moment this means of acceptance is actually employed. Okay, so let's look at an example. A, right? A is a company offers to sell 10 smartphones to a phone store, right? In the offer state that the phone store B, right? Let's say B. A is the company. B is the phone store. Okay, so B must accept the offer via DHL, overnight delivery. Okay, so the question is if B sent the acceptance using UPS, which is another carrier, overnight too. So do you think that the acceptance is effective and a binding contract is formed? Is the company offered to sell 10 phones, right, to B, which is the company. It's a phone store, okay? And in the offer, they say that it must the offer B must accept the offer via FedEx, okay? Overnight delivery, right? However, B say that send back the acceptance using UPS, right? Overnight delivery too. So do you think in this case the acceptance is valid and a binding contract is formed?
I think that according to the proper dispatch rule, the acceptance is not valid.
Okay, Châu Long. Okay, so the acceptance is not valid, right? So, exactly, right? So because they say that you meet not, because they already expressly this is an express authorization, right? Yeah, they say that must be by FedEx overnight delivery. So the acceptance, uh, if we send the acceptance to A using UPS, right? Then it does not. The acceptance is not effective, right? So if they actually use FedEx, if they actually use FedEx when the acceptance is effective, when the acceptance is effective, which moment? Anyone? Which moment that the acceptance becomes effective?
I think that in this case, the acceptance will become effective at the moment D send his acceptance.
What can you please specify? What do you mean by send?
The moment he dispatch that acceptance.
Yes, okay. So the acceptance is effective, right? And of course, the binding contract is formed the moment that B gives the envelope, right? If you do an exam, please specify, right? Gives the overnight envelope containing the acceptance to the FedEx officer, okay, or to the FedEx pickup driver, that whatever you can use, right? Or when he actually give the envelope to the post officer, right? The postman, right? Because when you do this thing, usually you're gonna ask for the receipt, right? And then in the receipt, they say that okay, the driver or the officer receive your mail right on this day and this day, and you can send that receipt to your offerer, and therefore at that moment under the U.S. law, right? Proper dispatch rule and the mailbox rule, it is that a binding contract is actually formed. Okay, so if the offerer does not, thanks to so if the offerer did not say, right, if they did not mention anything, right, a certain mode of acceptance, then the acceptance can be made by any reasonable means, as I mentioned before, right? Section 30, restatement second of contract, or also the rule under the UCC, section 2 dash but section 2206 1A. Okay, so at this time, the court will look at right the prevailing business usages and right other circumstances that the mode of acceptance used were reasonable, or they can look at the prior dealings between the party. And usually, if you made right, if it is reasonable to accept that the offer choose the means that is faster than the offerer choice of means, right? For example, if the offer is made by the normal mail, right? Then it could be reasonable to accept the offer via like priority, even you pay more or express. What? Okay. by faster method, like for example, to sign a scanned documents and send it as attachment via email or using overnight delivery. Okay. So usually the court will look at those situations, right, to decide whether it is considered as reasonable. Okay. Right. So here, this is what I say, right? Express authorization and implied authorization. This is just a summary of offer and acceptance. You can have a look at that. The slide is available on e-learning. Okay, so you feel free to have a look at it again. Now, last to review what you study. Now look at let's look at some examples. Okay, this one I will put you. You guys will be in group again, and instead of answering like usual, please write them down. Okay, I will create a response on e-learning, and then you will just post on that. Okay, I will create a forum on the e-learning one. Okay, so there are two scenarios that we will look at together. Okay, the first one is this. Second. There's a casino, right? Casino P, okay? Casino M, right? B is a player there, okay? And why B was gambling at Casino B, right? He became angry and he actually punched the dealer, one of the employee there. So he actually punched, right? He hit of Casino M, okay? So therefore, he was banned, right? So Casino M doesn't want B anymore, does not allow B to go to the casino, right? However, despite the ban, right? He still gambled at the casino and actually B won 9,000 US dollar. So when he tried to collect his money, the casino refused to pay. And B actually filed a lawsuit against Casino M for breach of a contract because he said that he had accepted the casino's offer to gamble. Right. So the question is, right? So the question is there a valid contract between B and casino M? Or in other words, can B collect the money from M? Okay, that is number one. Okay, that's number one. Number two. Okay, number two. A corporation, a company, right, offers to hire R to replace M, okay? And M already sent the company a notice of intent to quit, okay? Already sent a note intent to quit. Sent it a month ago, okay? And the company gives R a week to think, to speak on the offer, right? To decide whether he would like to accept or not. However, 2 days later, right, M actually decided not to quit, right? And signed an employment contract with the company, right? So not quit, not quitting, and signed a contract. Signing a contract, all right? And then later on, after this, the next day, M actually told her about that. I say, hey, I already signed a new contract, so I'm not quitting again. And after that, R immediately, okay, faxed a letter of acceptance to the company. That's the company. So the question is, let's see, right? Do the company and R have a contract? Okay, and any question, everyone? Right, so now let's be in a group, okay? And I will give you guys 30 minutes to do this because you also need to write, to type your response on the e-learning, okay? So 30 minutes. Châu Long, you have a question? Yep.
Yes, I have a question related to scenario 1.
Yeah. Go ahead.
B won $9,000 before he hit the employee or when?
After.
Oh, after.
Yes.
Okay.
So let me, so everything I put here is in the time order, okay?
Okay, I understand.
Order. Yep. All right. So
thank you, Miss.
yes, no worries. So after B hit the employee, so he was banned from the casino, right? So, and then after that, he still, right, despite the ban, he still gambled at the casino, right? Okay. Any other questions? Otherwise, I will put you guys in 3 groups. Maybe okay, maybe I just put four rooms and then you can choose which one, and you can choose your old partners, okay? And you have 30 minutes. I will send you the link of the forum that later on you can put your answers on. And please just say in the answer that you put, that you entered, that you actually, how can I say? Just don't give me the link of the Google Doc or something, okay? Just type the answer into the forum box, and then also include the name of your of the people who are working on the cases with you guys, okay? So if, for example, you have 5 people in the rooms but only 3 people work, then you just need to put 3, okay? So I will put 3 rooms, okay? And then you guys, we have 30 minutes for 2 examples, right? Okay, so now let's look at answers. Oh, I don't think, have you guys posted on the forum that I sent? Because I don't think I see any here.
Miss, you haven't sent any links to us.
I did send on the chat box.
Oh,
You can check that. I sent at 1:11 p.m. Or otherwise, you can just go to your e-learning under discussions and you're going to see March 3rd, 2022. And then you can just respond to that. Did you guys see it? Okay, maybe I'll give you guys, do you have any problem seeing that? Maybe Nghe, can you please check? If you see the discussions, the one that I put under class on the e-learning.
yes, I'm looking at right now, but how can we open this discussion?
Oh, I think one of you already sent. You just click on that. And then I think they will let you, maybe you can ask Hoàng Yến. Hoàng Yến can post, Hoàng Yến just, right? Yến, can you please share with the class how to post the response on the discussion, please?
Yeah. Mọi người vào phần discussion đó, ở học ở dưới cái link Zoom á, xong rồi mọi người bấm vào ngày tháng, ngày 3 tháng 3 2022, rồi nó có cái chữ phúc đáp á. Mọi người bấm vào là nó sẽ có cái chỗ để mọi người viết reply.
Okay, thank you.
Yeah.
Okay, let's, I'll give you guys another 5 minutes to complete that. And if you already posted the answer, then maybe please prepare and for some questions for me and maybe for other groups of your class. Okay. Okay, so let's see. Hmm. Mhm. Okay. So now let's look at each case one by one. Right. Okay, case number one. Each of them is very, very simple, right? So don't think too much. Just use what we have studied, what we have discussed so far, and you will be fine. So the first one. Second. Right. So the question is, was there a contract, right? So for number one, very, very straightforward. The answer is no. Right. Why? The parties must be voluntarily agree in order to enter into the contract, right? And if you were the court, right, and it should be decided whether an offer has been made objectively, right, not subjectively. Okay, so if you carefully analyze the case, the scenario, then you can see that according to the restatement second of contract, right, the test for an offer is whether it induces a reasonable belief in the recipient that the recipient can buy, accept, and buy the sender, right? And then the offerer, of course, can decide to whom to extend the offer. So according to the restatement and we study, right, the offer create a power of acceptance in specified person or in one or more specified group or class of person. They can act separately or together. Right? I gave the example before, right? So if the offer was made to one person, offer was made to individually to A and B, and the offer was made jointly to A and B. Okay. So in this case, the casino, right, can make an offer to anyone that they like. They would like to. So that simply stated, the issue in this case is whether. So the issue here in this case is whether the casino, right, and actually made an offer to be. Because of course, the casino M has the ability to determine who, right, they can let into their casino or not, right? Because the casino is theirs. So therefore, in this case, right, B was banned for life from the casino, right? And does not want B anymore, right? And does not want B anymore. And under an objective test, unless the ban had been lifted, right, B could not have reasonably believed that he was among the people that M offered, right, or among the people invited to accept M's offer. Right, so therefore, since there was no offer at the beginning because B was already banned by M, right, to go to this casino, there was no offer at the beginning. So therefore, there was the act of B gamble does not consider acceptance. So the A contract was not formed in this case. Okay, so this is scenario one. Okay. Scenario two. Scenario two is about which concept, guy? Which one that they trying to test us in this case? we study a lot of things so far, right? So which one that they try to test us? Which concept? Can anyone point out which concept that they try to test us in this case? We need to know what they are testing so we know the rules to apply, right? Similarly, the question is there a contract between the company and R, right? Is there a contract between the company and R? The answer is no, right? Because this one actually tests us the revocation, right? Whether we remember what does it mean by revocation. So a revocation, if you remember, as we stated before, right? A revocation of a bilateral contract, or this case, a bilateral contract is what? Anyone remember? Revocation, please. Anyone remember when we discussed revocation? What is a revocation in a bilateral contract?
Revocations mean withdraw.
Withdraw, yes. And can you please specify a little bit more?
And revocations must be expressed. Like,
must be expressed.
yes, like they must formally stated in a statement or contract.
Okay, or okay. All right, thank you. So according to form, the revocation must be expressly stated in the contract. Okay, anyone else, please? Any other thoughts? I went over this one a few times.
Well, revocation is also valid when there is an by the offer which is inconsistent with the offer.
I'm sorry, something inconsistent. Can you repeat that
Yes, the act of the offer that is inconsistent with the offer.
Yep. So can you clarify that? Good point. Yes, you hit the right point. Yes, and please.
Yes, for instance, when I offer to sell to be a house, that then I sell that house to another party, see, then it constitutes a revocation.
Good, thank you. Yes. So revocation, right, is the act of withdrawing, right, revoking an offer. Okay. So revocation may be accomplished by either way. Okay. The first one is what Fu said, right? Number one is that the express repudiation of the offer. Okay. I will withdraw my offer. Okay. Or number two, this is what Jolom added. Okay. The performance of an act, right, that is consistent with the existence of the offer and are made known to the offeree. There are two things, please pay attention. The first one is that it is inconsistent with the existence with the existence of the offer, right? And number two is that it made known to the offeree or the offeree's agent. Okay, so a revocation in the US, in most states, a revocation becomes effective when the offeree or the offeree's agent actually receive it. So in this case, right, the company did not say, I withdraw my employment offer with you to R, right? or did not receive that. However, first of all, there is the company actually did something that is inconsistent with the existence of the offer. It is to sign a contract with M, right? Because the position, M's position, R can only take the job when M's position is vacant, right? But M actually did not quit and signed a contract with the company. So first, right? So it meets so that one meets the first requirement, right? So inconsistent with the existence of the offer. And second, right? M told R, right, about the contract, right? So and that one is made known to the offeree directly. Okay, so therefore a revocation already becomes effective, right? So the act that and it become effective when R actually receive it, right? So after the revocation is made known to R and becomes effective when R received the information. However, R sent the formal acceptance letter to the company after the revocation becomes effective. Therefore, right, when the offer is revoked, it means it is terminated already. No, it no longer there, right? So R actually sent an acceptance to the company offer which no longer exists. So therefore, right, the acceptance is not valid, right? Not is not valid, but the acceptance does not constitute the contract. Okay, because the offer was no longer there, right? So that is very, very long explanation. But if you need to do it in the exam, or if you need to do it to your client or your boss later on, you just need to say, my question is, right, was there a contract between the company and R? So you just say no. Revocation of an offer may be implied, but the conduct is consistent with the offer and are made known to the offeree. So when the company hire M, right, and R learned of the hiring by M, the offer was actually revoked and the acceptance was too late, right? There was no, the offer was no longer exist. So the acceptance cannot construe the acceptance of A does not form the contract. Is it clear, everyone? So when you write an exam to me, right, you just need to be very brief and straightforward. When I explain to you, it looks very wordy, right, very long and complicated. But when you write, right, you just need to go straightforward and answer the point. But make sure to, how can I say, to have a very good support of your statement. All right. So, any questions so far? Yes, no, maybe. Okay, no. Oh, yeah, yes.
Yes, Miss, I have a question, but before well, answer questioning that one, can you please scan through our answer?
Yeah, sure.
Because for the first scenario, we have different answer to the question.
Okay. Oh, before I saw three, but someone deleted your is one group. Did one group just delete the response? So
No, miss.
no, I saw yours. No
Yeah.
worries. Yeah, okay. So, the act of becoming occurs before and after. Okay, Nia, can you please just explain so it's faster because I'm a little bit confused with the writing. Okay.
Yeah, sure. So
Yep.
for the first scenario, we have the answer that the contract, no, there is a contract between Casino M and B. So to conclude that B
Uh-huh.
can collect the money because we base on two arguments. The first one is prior dealings. So B gamble at the Casino M before and after being banned by Casino M.
Mm-hmm.
So
Yep.
despite the fact that Casino M said that Casino would ban B, but actually B still can operate. I'm sorry, still can play at the casino.
Mm-hmm.
That's prior dealings. The second one is Casino M plays a role of the offeree, while B is an offerer. So B takes the gamble at casino and win 9K dollars. That contributes to the
Mm-hmm.
profit of the casino M. So after the banning was announced, Casino M has the chance to reject B from the casino, stopping B from joining any further activities. But Casino M still let B did the gambling and still collect the profit from the clamping. I'm sorry, gambling
Gambling.
activity. Yeah.
Uh-huh.
So we base on two arguments saying that in the case Casino M was silenced and that silence indicate acceptance of entering into a contract. So the contract so there's a contract between B and Casino M and B can collect the money.
All right. Thank you. Sorry. Sure. Thanks, Nghe. So how do you guys have any comments on Nhe's group rationale? Anyone, do you have any comments or what do you think of the response? All right. So, how can I say? This is actually based on a real case, very, very complicated. But of course, the fact that you guys were provided is were simplified, right? So, of course, there are different scenarios. So, let me see. Okay, according to uh, the group, right? So saying that first of all is prior dealings. So when you say prior dealings, which principle that you would like to apply here? Nghe? Is it like silence? And silence mean acceptance because of prior dealings?
Yes.
Okay. So thank you. All right. So this if you look at the silent slide, right? This is bullet point number 3, I think. Right, if I'm not mistaken. Right, so prior dealings, it means that they were silent before, so they were silent now, and it shows that it is actually an acceptance, right? And so Nghe think that, I mean, the group thinks that B in this case is actually an offerer and M is actually an offeree. I'm not really sure about this rationale. Can you please specify a little bit why not M is an offerer? When I say that M is an offerer, I mean that how can I say, we the place offer for you to play the game, and you accept that offer by playing the game, and you actually won. That is what I'm looking at. So you're looking at from the other side. Can you please explain a little bit?
Yes, sure. So I think this one is quite similar to the contract between the supermarket and a customer. So, or an advertisement is like casino M just opens an invitation to join the contract. And when, for example, B or another person came into the place, the area, the building, and say, well, I offer the casino to join the contract with me. So B will be the offerer and M will be the offeree.
Okay, I see. Okay, so your is like you think that it is like an advertisement, right? A
Yes.
supermarket, an advertisement one. Okay, good. And what do you guys think of this? Very good point. So this is the issues, right? So okay, I will send you the case for sure. So because of course there are a lot of facts missing. So the court actually say that, right? In this case, if I'm not mistaken, all promises in contracts in agreements arise from wagers or bets are void, right? If the person is banned from the facility, right? It is not within the rules for the person to be present or to gamble at that casino. Okay, so a person who is excluded from a casino under the rule of a race and gambling commission, that is according to the legislation, would not hold a legally binding agreement with the casino for paying the winning, and the facility, the casino, therefore would not be required to pay winnings to such person. Okay, so the issue here is that because there was a ban that applied on B, right? So therefore, first of all, there was no first, right? There was no contract. There was no agreement between M and B first, right? Let's not look at whether who is an offerer and who is an offeree. B is banned from the facility, right? B is not allowed to be there, right? So he cannot either, right? Let's not discuss in the offer for now, right? Offer or accept the acceptance from Casino M, right? Because there was a ban and it has he cannot prove that the ban had been lifted by the casino before the day he actually entered the casino and played and gamble and won 9,000 US dollar 9K. Okay. And the court here actually find that M would not be required to pay winnings to a person involuntarily excluded from the casino, right? And actually this had a lot of rounds to review this. So in short, right, the first one is that they say if you are banned from the facility, right, you are not allowed to be there. And of course, if you want to make it like two scenarios, like the first one is if B can prove that M knew of his existence and still allowed, or M manager or the manager of the M casino knew of his, existence in the casino at that day and gamble and still allow that, that is a different story, right? Then of course you can use what you say before, silence means acceptance, right? However, if the other one is that there is no way for M to knew that B is there because this is a big casino and it's really and when you play, no one asks for your ID or anything, right? You just go there and play, right? Just sit down and play. If you use a machine, you just need to put the money in the machine and you just click the button and then the machine keep playing for you. So there is no way that M knew of B's identity when he entered the casino, because the casino there are a lot of people in and out every day. So if you really want to do it like that, you can make it into two scenarios. Do I make it clear, Nghe and the group?
Yes, it's clear to me.
Yep. Okay. So yeah, the priority links here and in both as so you can say as what I mentioned before. Either you can keep it as your path, right? And you make it into two situations. The first one is acknowledge aware. M was aware of B, right? Gambled at the casino on that day. And number two, M did not. M was not aware of B existence or B entrance into the casino on that day. Okay, and then you can just go on with your path. All right. Okay, any questions so far? Any other question for this? All right, so before Nghe actually mentioned a very good thing. I mean, very, it reminds me of something. So maybe I just have a quick ask to you guys. So when you do a problem solving question, right, in class, or when you actually intern, maybe some of you are interning. So if your boss asks you to solve a problem solving question, either for example, they have the case and they ask you maybe to give a brief or to answer certain question, or you need to write a memorandum to your client, right? Or your lecturer asks you to do an exam. How do you present your answer? Is there any model that you use to present your answer, or you just write whatever you think? Do you follow any structure at all? Is there any specific structure that you follow in order to and to give a organized and structured answer?
So I would use the IRAC method.
Okay. You guys study that?
Yes.
Oh, that's good. Hold on one sec. I think one of you say something. I read good. Thanks, Nghe. So good. How come you guys study that? And never mind. Okay. So Nghe, could you please, or anyone else, fine. Can you please briefly explain IRAC just in case many of you already forgot? What is IRAC, Nghe? I is
I is for issue.
R,
R is for regulation.
regulation. All rules. Okay. Okay. A.
Sorry, I forgot the A one.
A is application.
Oh, yes, application, and C is conclusion.
Right. So very good. So this is the suggested. I'm not saying this is the best. I'm just saying this is the suggested. There are other like red. Right. There are many available out there, but this is the simple one that I could recommend to you guys. But then later on, of course, you can choose whatever suitable for you. Right. And so when you are asked to solve a legal problem, this is a suggested structure. You don't write a whole essay, right? You just need like a paragraph to answer everything very briefly and straightforward, right? So issue, what is issue specifically? Nghe?
I'm sorry, Miss. Issue is the issue of the problem, the question you need to answer.
Yep. So when you read the whole scenario or when you read a lot of information, right, given by either your boss or your client, you need to identify the issue, right? You need to identify the issue. What is the legal problem, the legal issue in this case that you need to solve, right? Not every question is the legal problem, right? And you need, for example, if so you're gonna say the issue is, right, whether the act of B, right, is binding because of there exists an implied in fact contract between the parties. Okay, that is an issue. This can be a question, that could be a statement, right? And in any format. Or for example, you're gonna say, if this employment contract is an employee or an independent contractor, right? For example, if you need to discuss the benefit of an employee versus an independent contractor, right? So that is, you identified it, and then you need to state an issue in your response in an email, in an essay, in an exam, or later on when you actually work. Or, right, it is regulations, right? So you're gonna look at the legal principles, right? And from there, the legal rules that apply. The legal rules gonna consist of what, everyone? When we talk about legal rules, what are we looking for? What are we talking about? What do legal rules consist of? The legal rules consist of what? We need to know what it is, right? In order to identify it. Yeah.
Oh, yes. Can you hear me?
Yep.
So the regulation or the rules, we can look it up in the code of the system of
Yep.
that country.
Okay. Anywhere else? Right? Or the custom or any other places? Is there any other sources that we can look at? So there are two sources, right? We call the primary sources of law and the
Secondary.
secondary, right? So the primary sources of law is what Nga said, right? Legislation and or cases, right? Case law, precedent, right? So for secondary sources, we have a lot like legal dictionaries, right? Textbooks, right? Commentaries relevant to specific area of law, right? So these are the sources that you want to look at to identify the legal rules that can apply to this specific legal issues that you are working on. Okay, so we, for example, right, if we need to look at whether A is an employee or an independent contractor, maybe we can look at the first step to understand the relevant legal principle, right? We can open dictionary or we can look at the law, right, to see what is the definition of an employee or of an independent contractor, right? Is there any test, any identify any factor test, right? In any case law, right? So maybe, and then later on, maybe we can say in one sentence like the current test, right? Or the current definition for determine whether a worker is an employee or an independent contract is according to the employment law, the employment code, right? Or is the multi-factor test confirmed by whatever case law it is? Okay, so we identify a lot of things, right? We read a lot of things, but we're gonna state the legal issues apply to the legal rules apply to the issue, right? And it should be stated as a general principle and not a conclusion to the particular case being analyzed. Okay, so this is the second step. Application, as the name itself, right? The name suggested that you're gonna apply the rules to the problem, right? You're gonna apply the rules to the problem. This should be the most important and the longest part of the answer. You're applying the rules to the facts of the problem or the question, right? You're gonna state your evidence, you explain how you arrived at your conclusion, and you're gonna use the relevant precedent cases, legislation, or any statement of legal principles to support your answer. Right? And of course, I'm very open to different, how can I say, different answers, right? There's not only one answer, as long as you can support your arguments well with evidence or cases or legislation or the statement of legal principles that are like you can say, okay, according to the legal, according to, you can say, revocation, right? According to the legal principle of the revocation of bilateral contract, this is this, and that. Okay. So, or if you want to see whether something is an implied in fact case or contract, then you can look at the requirement that needs to be met, right, in order for a court to decide that it is an implied law contract. We discussed that before as well. Okay, and then you're gonna have you're gonna state that the application in your in your response. Okay, and the last one is the conclusion, right? It's a conclusion. So it's your answer. And usually there's no 100% right? The process of legal reasoning that actually leads to your conclusion. Okay, so maybe let's look at this one to see how you want to do this, because I received many exam, the written one, and you guys just write me a whole essay, and then there's nothing in there, right? There's nothing in there. So even though you write very long, but you get only 0.5 or only 1 point out of 10. So which I really don't want to, but it looks very long, but it has nothing in there. Okay, so let's look at the scenario, for example. Okay, P follows the Instagram of D. Okay, she's a very popular on social media. And on 25th of January 2020, okay, P saw a post by D with the caption that, right, limited time only, please join me in celebrating the launch of a book. Okay, maybe contract law. D is actually a lawyer, right? Very famous lawyer, right? A contract law book. And they access the digital version for free, and you can complete the questionnaire before the midday to win, right? One lunch, one meeting with D, for the lawyer, right? And the link information is in the bio. You know, you use Instagram, so you know that, right? Right, and P actually opened the magazine on her mobile, began reading, right? But got interrupted by some relative who dropped by unexpectedly, and she tried to do it after dinner, and she received an error message on her screen, right? She then noticed later on at 8 p.m. right, that D actually updated on the Instagram stories, and thank you for the overwhelming support, right? And our server clash, we sadly closed the competition as of now, right? And P was very upset because she believed that she still had a few hours to finish scrolling through all the pages, right? By midnight, right? So in this case, and then by 8 p.m., D already say that the competition closed, okay? Right, so if, right, P was very upset. So do you think that P there's a free lunch, right? There's a free lunch. Right. So do you think that B can claim the free lunch with D successfully? Right. My question is that. So what is the issue? What is the issue? To get the scenario. What is the issue here, everyone? you answer this, right? Now I'm walking you through the sample answer, right? What do you guys think? So someone answered whether revocation of the offer is valid or not. Okay, thank you. Anyone else? Okay, so the issue here is very simple, right? It is whether is there a valid agreement was formed between P and D. Okay. What is the legal issue? What is the rule? I'm sorry. What is the rules? Right. So if we up the rule, right, the traditional approach could be in order to establish the agreement, right? There should be an offer and acceptance, right? And offer is determined, and there is actually a lot of famous case, right? So if you look at, you guys have to study that. So an offer is determined, can be determined objectively, and for unilateral contracts, acceptance occurs by the offeree's performance, right? We already studied this many times, okay? And this is actually a rules. Application, how can we apply this one? How can we apply this one? All right, so how about I give you, let's have a break for 15 minutes. Let's be back at 3. During that, you can think of this one, how to apply and conclude this case, okay? So let's have a 15 minutes break, guys. We will get back at 3. You can have spend more time to think of this as well.